Welcome to the debrief, everybody. Testimony has resumed after a 4-day break in the retrial of a man accused of murdering a mother and her 3 children. Prosecutors say Henry Segura is the one who in 2010 killed his girlfriend, Brandy Peters, their 3-year-old child, and Peters' twin 6-year-old daughters. The motive, prosecutors say, was Segura's $20,000 child support debt. Segura says he's innocent and that Peters was the victim of a drug cartel. The defense says Peters took $100,000 in drug money and that the cartel left a calling card when it killed her and the children. A jury in Segura's first trial deadlocked after 19 hours of deliberation. The defense says James Carlos Santos knew the victim and called for the cartel hit, which killed Brandy Peters. Santos is in prison, but he signed an affidavit for the defense with the following, which you'll now see in his own handwriting. Remember, the defense is promising to jurors that they will hear about what you're about to see.
You're going to hear about Carlos Santos.
Henry Segura's defense says James Carlos Santos used to be a member of a Chicago-based gang.
Santos is a drug trafficker who brought Brandy in at some point in the 2000s to work for him as a mule.
The defense says victim Brandy Peters shuttled drugs between Texas and the southeastern United States at $8,000 per trip. Peters is said to have made 2 trips a month. Court documents from 2016 say Santos warned Peters her life was in danger after the cartel caught her skimming money from the cartel's cut of the profits.
It was a significant amount, and he knew at that point it was on him to take care of it, otherwise he would be taken care of.
Later, Santos said he was the one who actually called for the hit. In a letter directly to the judge, Santos wrote of Peters and the cartel, "She wronged us, I gave the order." Later, in a letter to the defense, Santos wrote, "Ms. Peters was murdered mainly because she crossed me. I have no remorse for her nor her children. I ordered these murders." That's what Santos says, but prosecutors say it's Henry Segura who's the real killer.
Today in court, another of the defendant's friends testified for the state that Segura had a gun, and the friend and Segura shot bows and arrows together as well. The defense pointed out that Segura apparently did not seem to know how to aim very well. Here's both direct and cross-examination.
I know he had pistols before.
Do you remember whether it was a revolver or a semi-automatic? You know the difference between those two?
I know that he had, I've seen him with both.
I'm sorry?
I've seen him with both.
Seen him with both?
Yes, sir.
And approximately how you've seen it a couple times then?
Yes, sir. Just, I mean, he had one.
Can you describe how successfully he was shooting at the target and how he was able to do so?
I mean, I don't think he'd ever tried it before, and it was kind of awkward for him, and he kept twisting the bow instead of holding it straight, and he missed quite a few times.
And were you aware at that time that Mr. Segura had been shot in the abdomen and was still recovering?
Yes, sir. I'd heard about it.
And you'd been on jobs with Mr. Segura as well, close in time to the murders, correct?
Yes, sir.
And Mr. Segura was still limited at the time. He hadn't yet returned to a full workload, correct?
No, sir. I don't believe so.
He wasn't able to carry heavy objects and things of that nature yet?
No, sir. I don't think so.
The state also today suggested defendant Henry Segura was far from a loving father to victim Javante Segura. The defendant sent this letter to the Department of Revenue in July 2010 to question whether he was really Javante's father.
I am petitioning the court to order a paternity test concerning the minor child, Javante Segura, born on or around July 28, 2007. Newly discovered evidence relating to the paternity of said child has come to my attention since the signing of the birth certificate for the minor child, Javante Segura. This evidence was presented to me in the form of a recorded voicemail left by the minor child's mother, Brandy Peters, on my home phone. In the message, she stated that I was stupid for signing a birth certificate for a child that was not even mine. She also stated that at the same time that she and I were engaged in a sexual relationship, she was engaged in a sexual relationship with someone else that she claims is the father. It is for these reasons I am asking the court to order a test for paternity and stay any order of child support until the results of the paternity test are known.
Segura was supposed to pay Brandy Peters about $700 a month for child support. Records show Segura was behind on his payments by more than $20,000. The state tried to show Segura had a lot at stake because of that debt.
By November of 2010, there had been six, total notices sent to the defendant informing him of what he owed.
Yes,
He'd also been informed, as we saw through these notices, by mid-November of 2010 that his tax return was going to be taken, right?
yes,
That there was going to be a lien on his property,
correct.
that his driver's license or professional licenses would be suspended or revoked,
That's correct.
and that he could go to jail if he didn't pay.
That's correct.
Department of Revenue also restrict a person's ability to get a passport if they owe a substantial amount of child support.
Yes, we do. If you owe more than $2,500 in arrears, we certify your with Department of State that you owe that balance, and you're not able to get a passport until you either do a written agreement with us or work out some arrangement with us.
Okay. And did you tell us the amount, I'm sorry, that you...
$2,500.
So if you owe more than $2,500, you can't get a passport and leave the country?
Correct.
All right. And he, obviously owed about $20,000 more than that?
That's correct.
That passport was to get a job overseas welding. Tallahassee police tested different areas of the victim's home for DNA to see who was actually there. First, they tested the front door. Some areas tested positive for a mixture of the victim's DNA and that of an unknown person.
Brandy Peters was the major contributor, and I couldn't determine a type for the minor contributor, but it was male.
What do you mean you couldn't determine a type? What does that mean?
It was so little DNA, the only allele that showed up was the Y.
Next, turn to also the front door, the interior deadbolt of that front door. Did you make a determination there?
Yes, and I determined there was a mixture of DNA there. Brandy and the girls were included in that mixture. However, there's one foreign DNA to both of those. Well, I know that there's no Y, so that would indicate there's probably a female.
So the exterior door handle of the front door. Did you make any determinations as it relates to that?
Yes, and I found a mixture on that door handle as well.
And what were your determination?
Brandy and the girls are included, and there is a Y present, so there is a male included.
We know it's a male that had been touched at some point or another, but that's all we know.
Correct.
Police also tested for DNA under victim Brandy Peters' fingernails. There was a hit for unknown female DNA under Peters' right index finger.
I developed all 13 markers from the nail scrapings, and it matched Brandy Peters, but there was a foreign donor below our callable limits.
Okay, so what does that mean, below our callable limits?
Those peaks have to be a certain height in order for us to use them, because below a certain height, they're not reliable, because they might have another peak that goes with them that didn't amplify at all. Just basically, we don't have enough DNA. And our analytical threshold was 50, and the callable limit is 100. So if there's something between 50 and 100, we put a star on it, saying, well, it's there, but we can't really do much of anything with it.
Perhaps the most important DNA hit was in the bathroom. The defendant could not be excluded from DNA found on a grab bar in the bathtub. That's the same tub where the bodies of the 3 children were stacked up.
I developed a partial profile. It appeared to be a mixture of 3 or more people. All of the victims are included in that. And there are 2 starred alleles, again between 50 and 100 RFUs, that are foreign to all of the victims.
And again, we're talking about the starred alleles at 2 different locations, correct?
That's correct.
All right. And you had Henry Segura's DNA, and the starred alleles are, you can't make calls based upon the FDLE protocols, correct?
They could be used for exclusion.
But
they
not
cannot
inclusion.
be used for inclusion.
Okay. And did you also make comparisons as it relates to Henry Segura using that chart that we talked about in State's Exhibit number 148?
Yes, I had to say that I could not determine. There was no determination for Henry Segura.
Okay. So you could not exclude him, is what you're saying?
Correct.
Attorneys Joseph McBride, Michael Bryant, and Catherine Smith are with us tonight. So, Catherine, what we have here sounds like a quadruple murder that's wrapped around some kind of a soap opera. We've got the defendant contesting paternity for one of the victims. This makes him look like a not such an okay guy.
I mean, he doesn't sound like a great guy. He might have dirt in his hands, but he doesn't have blood in his hands. His DNA is absolutely nowhere that it should be for someone if they committed these crimes.
It sounds like I've heard that phrase somewhere before, like perhaps here on the debrief. I think, Michael Bryant, is the DNA on this grab bar in the bathtub enough to really get this guy, or is it too squishy in your opinion?
Yeah, I mean, first of all, he lived there with this girlfriend enough to be spreading his DNA all over the place. The fact that it may have been his DNA on the grab bar, I mean, it's something, but you would hope for more if the prosecution is going to prove their case.
Okay, it's one thing now here, Joseph, to raise reasonable doubt. It's another thing for the defense to turn around and say, we've got an alternate suspect, we're going to name him. We have letters from him, and they're promising that this Carlos Santos is going to get up on the stand and basically admit to all of this stuff. That's a great defense case, it seems.
True indeed. It makes you wonder if the prosecution has a good faith basis to go forward. Mr. Segura has been excluded via DNA evidence to this point in the trial. They have tried to create a nexus between a failure to pay trial support and motive for murder. That just does not make sense. It's a weak case, and I'm interested to see what comes forth.
I mean, it might on its own be enough to prove a case like this, but it seems to me like perhaps a more compelling narrative here, Catherine, would be to say, hey, look, there's drug running, there's $100,000. You got this guy saying he called out for a hit. Here it is in his own handwriting. We looked at it today. We're allegedly going to see it here. The defense promised us this testimony. Where is it? I want to see it.
If we had just one of those things that you mentioned, that would be enough for reasonable doubt. The quantum of all of this doubt together cannot lead me to any other conclusion other than reasonable doubt.
So, Michael Bryant, is this why the first jury was deadlocked in the first trial?
Remember, in favor of a defense acquittal. So I think this case is going to turn on the defense witnesses. If the jury believes these cartel, mob, drug guys, I think it will kill the prosecution's attempt to get this guy beyond a reasonable doubt.
Well, you know, Michael, it's kind of sad when the defense has to try to prove a case because that's not the defense's job. The defense doesn't have to prove anything, and I'm getting people agreeing with me. Yes, I just played defense attorney here on the Daily Debrief. Let's move on to some other cases we're following now. The suspect in the disappearance of 4-year-old Houston girl Malia Davis didn't show up for his arraignment today. A grand jury last month indicted the victim's stepfather, Darian Vance, on charges that he injured a child. Vance allegedly struck Davis with his hand and a blunt object and then purposefully cut off her airway. There's still a key piece of evidence in Malia's autopsy yet to be released to the public, which law enforcement says they won't release until they conclude their investigation. Vance's court date was changed to this coming January 22nd. He remains in jail on a $90,000 bond. Jury selection underway in the trial of a Florida man accused of murdering his wife. Dr. Teresa Severs was bludgeoned to death at home in 2015. Mark Severs, the husband, was one of 3 men charged in the killing. Co-defendant Curtis Wainwright Jr. pleaded guilty to second-degree murder in 2016, and a jury convicted Jimmy Ray Rogers of second-degree murder last month in a case we brought you right here on Law and Crime. Mark Severs, the husband, is charged with first-degree murder and conspiracy to commit murder. He could face the death penalty if convicted. And still ahead tonight, an update on the trial of a Colorado fiancé charged with murder. We'll have that update from the scene. Plus, a hearing to keep evidence out of the trial of a man accused of killing Iowa college student Molly Tibbets has quite the legal history. We'll run through those cases when we return. An update now on the trial of a Colorado fiancé charged with murder. Patrick Frazee is accused of killing Kelsey Barrett with a baseball bat and asking his girlfriend on the side, Crystal Lee, to help clean up. Local reporter Jennifer Meckles has been in court every day and spoke to Law and Crime about evidence prosecutors trying to use to back up Lee's testimony against Frazee.
We heard her say things like he was planning this, he wanted to get rid of her, he was finding all sorts of ways to try to do that, he was trying to get Crystal to help him do it. And then one of the witnesses that followed Crystal was a man who testified Friday afternoon that he was a longtime and close friend of Patrick Frazee's. Patrick Frazee is a rancher, he has cattle, he is a farrier for horses, he has a lot of property that he leases in the very rural mountains of Colorado. This is a friend who did a lot of that business with him. It was incredibly heartbreaking testimony last week. He was very upset that that somebody he thought he was very close to could do something like this. But he said that Patrick talked about killing Kelsey, that he made comments like, no body, no crime. In this case, Kelsey Barrett's body has not been found. It's been looked for. They spent 50 days searching a landfill for it. We still haven't learned of any discovery of her remains at this point. This man testified that he was told by Patrick Frazee that Patrick was watching Kelsey, that he had people watching her, taking pictures of her and doing things around town. He said that Patrick was trying to prove that Kelsey was not a good mother to the little girl that they had together and that he wanted full custody of the baby. And this friend said that, you know, when Patrick made these comments in the year before this happened, he always brushed them off. He thought it was a joke. He didn't think anybody was being serious, and it bothered him. He said he was uncomfortable with these statements by Patrick. He never thought it would lead to a murder trial.
Cameras are not allowed in that proceeding, but we will keep on top of it as best we can. A hearing this week will determine whether statements made by a man accused of killing an Iowa college student will be used against him at trial. The hearing will seriously affect the case. Here is a look at what we expect.
Police say this man, Christian Bahena Rivera, gave them turn-by-turn instructions on where to find the body of Iowa college student Molly Tibbets. When police first spoke to Rivera, he said he knew nothing about Tibbets. Later, he let police search his Chevy Malibu, which was similar to one seen circling 4 or more times where Tibbets was last seen jogging. Inside the trunk, bloodstains and her DNA. At issue is what the state calls an unfortunate failure by a police officer to read Rivera his full Miranda rights in an interview at a police station. Court documents say the officer did not have access to a Miranda card and failed to tell Rivera that anything he said could be used against him in court. The state called the warnings nearly complete because the officer did tell Rivera that he had the right to remain silent and to speak to an attorney, but the state concedes what Rivera said should be suppressed. Prosecutors say Rivera went from a denial of killing Molly to not remembering and said he had a memory problem because he hit his head on a goalpost while playing soccer in Mexico. He shifted and said it was possible he did something to Molly but just couldn't remember. He then admitted using a vacuum to clean his car and admitted to being on a gravel road in Malcolm, Iowa at 4 a.m. when Molly disappeared. After asking other officers to leave the room, Rivera told one officer he remembered fighting with Molly, putting her in his car, and that there was blood. He couldn't remember if Tibbets was dead or alive, but he did remember that we were in the corn. That's where I put her. Then Rivera led officers to the location where they found her body. That's where Rivera received his full Miranda warning. After receiving it, he continued to talk. The state relies on a 2004 U.S. Supreme Court case to argue that while these statements must not be used at trial, any physical evidence found can be used.
The bottom line here is that all of the statements you just heard from the defendant will not make it into the trial. The state agreed they should be suppressed, as we said. In case the local police have forgotten the 1966 holding of Miranda v. Arizona, here it is. Prior to any questioning, the person must be warned that he has a right to remain silent, that any statement he does make may be used as evidence against him, and that he has a right to the presence of an attorney, either retained or appointed. But, of course, there's been a slow erosion of that pure Miranda decision. In one recent Iowa Supreme Court case, Justice Brent Appel explained the status of the law in his dissent. In the aftermath of Miranda, the United States Supreme Court has embraced its core holding, but generally limited the potentially protean scope of the case. But the justice said state Supreme Courts have not consistently followed the U.S. Supreme Court's later case law under Miranda in the interpretation of their state constitutions. In other words, state courts can give defendants more rights than the federal Constitution allows. Keep in mind, that's the same justice who, as a practicing lawyer, argued the second of the legally famous Christian burial cases before the U.S. Supreme Court. In those cases, the court examined an Iowa suspect's confession. Suspect Robert Williams said he wanted a lawyer but didn't receive one, and the police, knowing the suspect was religious, said that the 10-year-old victim they suspected him of killing deserved a Christian burial. The U.S. Supreme Court suppressed the words of the defendant's confession, but ultimately ruled that prosecutors could use the body the defendant led them to find. The reasoning? Because someone would eventually have found the girl's remains anyway. This case reached the U.S. Supreme Court both in 1977 and 1984. And here we are. Legal history seems to have repeated itself in Iowa, as it often does. Michael Bryant, question for you here. It's sort of amusing in a way to read a judge basically talk about the erosion of Miranda rights when he, as an appellate litigator, basically contributed to the erosion of Miranda rights.
Yeah, you know, isn't it what we're taught to argue out of both sides of our mouths? I mean, that's what attorneys do. You take a position, you make an argument. He was in a very different place when he made argument A than when he made argument B.
Exactly. Okay, so Joseph McBride, it seems to me here that when we watch this hearing go through in the Molly Tibbets case, it's likely that the court's going to follow both 2004 and more distant past U.S. Supreme Court precedent and turn around and say, okay, we'll agree to suppress the statements, but the body that Christian Rivera led authorities to, the body of Molly Tibbets, we're going to use all the physical evidence here.
It's possible under the doctrine of inevitable discovery. I certainly hope that doesn't happen in this case. It is unfortunate, this type of circumstance here, but the police have a job to do. They have to have a fully Mirandized person in interrogation process. That person has to actively waive their right to counsel. If they don't, they suffer the consequences of the fruit of the poisonous tree doctrine.
Yeah, and Catherine, I want to know factually here, and this is what I expect to come out tomorrow, just how hidden the body was, because they've been searching for it for what? A month? More than a month? Nobody found it. So how inevitable would the discovery have been?
Well, that's the thing. Inevitable discovery is actually a term of art. It's not just a common sense rationale. And in fact, it has to be shown that by a preponderance of the evidence, a normal police investigation would have led to that evidence. So if I were the defense attorney, I'd say, listen, it's proof here. We didn't find it. So would it have ever led there but for the statement?
You know, it's such a sad case when we look at the facts underneath it. We've got the law here. This is an interesting case, Michael Bryant, to unravel from a legal perspective. And we've got the defendant in this case, the Tibbets case, basically continuing to talk after he got his second Miranda warning. So there's a lot more statements that probably will come in. What we talked about just moments ago right here, it'll be suppressed, but is it really going to matter?
I don't think so. I think if you look at the facts leading up to their initial questioning of the defendant in this case, they saw his car in the area. It was reported, it was on surveillance where the victim was jogging that night. That would have led to the interview of the guy who owned the car, which is what happened. That would lead ultimately to examining the car, which is what happened, and they found evidence of the victim in the trunk. I think all of that comes in. I don't care what was said.
And look, if the defense wants to try to win a Fifth Amendment case or some sort of a due process violation under the Iowa Constitution, because that's how Iowa looks at it, they better try to get these statements suppressed under the state constitution. That's what the Iowa justice said was the best route reading that case. Thanks a lot to the panel. That's all our time here on The Debrief. We'll see you back here tomorrow at 5 p.m. Take care.